Good afternoon. Good afternoon and welcome to everyone. We're so happy that you were able to join us today for FOIA Challenges in Immigration. My name is Mosheim. I'm the Chief FOIA Officer at the Consumer Product Safety Commission, and I'll be moderating today. Our panelists are Emily Creighton, I hope I pronounced your name correctly, Legal Director, Transparency at the American Immigration Council. We also have Claudia Valenzuela, Managing Attorney at Immigration Legal Defense, and Bradley White, who's the Senior Director of Privacy and Policy and Oversight at the Department of Homeland Security. So the format for today, I will be going through questions after we have each of the panelists give us more about their background. And then feel free to put your questions into chat or Q&A, and we'll get to those at the end. But with that, I will go ahead and ask the panelists to go ahead and tell us more about their backgrounds. So Emily, would you like to start?
Sure. Thank you, Abby. It's such a pleasure to be here today. As Abby mentioned, I am the Legal Director of Transparency at the American Immigration Council. And so we've carved out some space to do transparency work with a small but mighty team at the Council. And Claudia was with us at the Council for some time. The Council is an organization that works to strengthen our country and democracy by working towards a fair and just immigration system. We think at the Council that this system, the immigration system that we deal with every day, needs to live up to our highest values and ideals and afford basic due process rights, as well as meet the needs of those who seek protection. And transparency is important, including the use of FOIA and state open access laws to obtain information is critical for government oversight. And so we use FOIA's on open access records laws in our strategic litigation, advocacy, and research to ensure we meet our transparency and accountability goals. And so that the Council, we're focused on several areas, policy areas, but I'll just say that transparency has been very useful in addressing the overuse of enforcement in the interior and on the border, and failures to provide due process within the immigration court system, and systemic problems within the federal FOIA system. And I'll end there.
Thank you, Emily. Okay, Claudia, would you like to tell us more about your background, please?
Sure, thanks, Abby, and thanks everyone for joining us today, and thanks to my co-panelists. I'm really in good company today, I see. My name is Claudia Valenzuela, and as Abby mentioned, I am a managing attorney with Immigrant Legal Defense, which is an Oakland-based nonprofit organization primarily focused on direct legal services to non-citizens in a range of matters, but also, as with any practitioner in the immigration arena, invoking the tools of FOIA and transparency, both in terms of individual client cases, as well as in terms of exploring government functions, in our case, federal immigration agency functions in various matters that continue to impact us in the immigration arena. And with that sort of dual focus, just always looking as well, working with partners like the Council and others, so many others out there that are working towards a better system to continue to further transparency, to make it accessible, to reform in terms of delays, because for many individuals, delay is really the biggest challenge in terms of accessing information, both in terms of individual cases and governmental operations in a systemic manner. And I look forward to today's panel and to answering questions by folks, but I'll end there.
Thank you, Claudia. And Bradley, please tell us more about your background.
Sure. Thank you, Abby. Good afternoon, everyone. My name is Bradley White, and as Abby said earlier, I am the Senior Director for Privacy, Policy, and Oversight in the Department of Homeland Security's Privacy Office. I'm relatively new to this role, and in my previous life, for 12 years, I worked on FOIA issues. I started my career doing FOIA processing and FOIA litigation with U.S. Immigration and Customs Enforcement. Afterwards, I was the FOIA officer for the DHS Office for Civil Rights and Civil Liberties. And then I moved on to be the senior director for FOIA litigation and policy, also at the department. So I've got a lot of FOIA experience, and now I'm kind of shifting over to the privacy side of the office, see what we do. But I am looking forward to this conversation. And again, I thank you all for having me.
Well, thank you all for being here. And with that, I will start with our first question, which is directed to you, Bradley. Describe the FOIA process at the Department of Homeland Security, including the different types of immigration records and the different sub-agencies that fall under DHS. Just give us more of a picture of what goes on there.
Gladly, thank you. So generally, FOIA processing at the Department of Homeland Security is decentralized in that we have a headquarters FOIA office, which is located in the privacy office. And then each of the components, especially the main larger components, have their own FOIA offices that handle their FOIA requests. Components, so that's Immigration and Customs, U.S. Customs and Border Protection, CBP, each have their own FOIA offices. ICE and USCIS have centralized FOIA offices that process those all
Bradley, we're getting, you're cutting out. It's kind of stalling, and right now you're frozen on my screen. So I don't know if you can hear me, but you might.
Immigration records that they get, and what's called the National Records Center. Guys.
Oh boy. So I think that Bradley, at least from my end, is gone. Emily and Claudia, is that the same for you? I can no longer. Okay.
Am I back yet?
Now you're back. Yes. So started kind of in and out at decentralization. So if you want to go back there, that would be wonderful.
Okay. I am sorry. Then the kids aren't even in school anymore.
Problem.
That's just terrible internet.
No problem.
Okay. So the immigration system, the records are decentralized in that FOIA is decentralized in that most of the components, especially the larger components, have their own FOIA offices. For the sake of immigration records, U.S. Immigration and Customs Enforcement, ICE, has its own central processing FOIA office that handles all FOIA requests, including immigration records. USCIS, which is the custodian of the A file that maintains most of the immigration records that people need. They have a central office that handles those requests. It's located in a cave in just outside of Kansas City, Missouri, called the National Records Center. And they have a very large operation there, at least compared to everyone else. And then Customs and Border Protection, CBP, has a headquarters office that handles a lot of their requests, but then they also process some records out at the field level. To the extent that we're here talking about immigration records, I'm going to talk generally about USCIS and where their records are stored and what they have, and then also the process with getting other records handled. So the A file contains benefit records, it contains records related to immigration proceedings, and it contains records relating to any removal proceedings or law enforcement activities. So ICE and CBP will put records regarding a person in that individual's A file. However, there are also other systems maintained by ICE and CBP and USCIS that also have electronic records. So when folks, and I know that Emily and Claudia can verify this, a lot of times when someone will file a FOIA request, they'll seek their A file from USCIS, and then they might also file a separate request with CBP for any entry and exit records that would be relevant. They might file with ICE for any records related to enforcement actions. And there's another component, OBIM, the Office of Biometric Identity Management, whose records are processed by the DHS Privacy Office. They receive about 45,000 requests a year, so they are not really a small part, just small compared to USCIS and ICE. And those records are immigration records, but not in the immigration file. So I'm certain it can be difficult to know where to file those requests, where to get what you need. People who've been in this field for a long time know where to go, but even then it can still get confusing. Adding to that confusion is, again, as I mentioned, since the A file is the central repository for all those records, what's in the other systems should make its way to that A file. So when USCIS gets a FOIA request and they encounter those records from the other agencies, if they either have an agreement from, say, CBP that will allow them to process CBP records, or from ICE that will allow them to process ICE records, or they have to refer those records or send them for consultation so that the other agency can apply any FOIA exemptions and make the release. That is a very simplified version of what can be a complicated process sometimes.
Yeah, it does sound very, very complicated. So Emily and Claudia, from your side of it, what does the FOIA process look like to you? Like, what records are necessary for litigation, for policy, advocacy, and why do you have to use the FOIA to obtain them? And either one can go first. And we'll start with Claudia. How's that?
Sure, thanks, Abby. From the immigration requester community, I would say there's essentially two buckets of ways that we use FOIA. One is in individual cases for non-citizens seeking to either apply for immigration relief or defend against deportation. And that's the bucket of folks that, we refer to as the individual requester community in terms of the direct service. The second bucket is the search for policy-related documents, what I'll call the policy bucket. Really, in my view, what FOIA was intended for. Obviously, we know that courts have often used the phrase that FOIA is a tool for citizens to know what their government is up to. And this is exactly what many of us in the immigration requester community utilize FOIA for as well, in addition to the A file necessary, as Bradley has outlined, for a specific immigration case. And essentially, in the individual cases, the importance of these documents that are really mostly in obtainable from the government entities that are implicated here. It is a process that can be a little bit, somewhat like an expedition to gather information about one's history in the United States. It's extremely important for immigrants and their attorneys to understand an individual's procedural history in the United States, and in terms of what remedies someone might be eligible to apply for. And without certain documentation, it can really hold someone back from being able to pursue an inquiry or lawful status in the United States. And also, there are many benefits that are linked to timing, benefits that may be linked to when you filed a petition, who filed it, how old was an individual. These are often pieces of a puzzle that individuals need to FOIA to be able to put together in their cases. And of course, for the folks defending against deportation, it's really crucial, obviously, to have oftentimes documents that are in the A file as well. And those individuals are facing, obviously, the threat of deportation immediate while in government custody. And so that often becomes a need, a more urgent need in some ways for that track of folks. Ultimately, I think it is a good question to ask, why must individuals seeking copies of their own A files, why must that be funneled through FOIA? Because the reality that we're seeing on the ground, and I'll let Emily talk a little bit more about the policy bucket, is that A files make up such a huge part of the queue, the FOIA queue for the agencies, that can impact, in our experience, how quickly we may get policy type documents. But also it just ends up slowing the access for everyone.
Okay, thank you. Emily, would you like to add to that?
Sure. And I think I will talk a little bit more about the first person requester issue in response to a later question. I'm going to follow up with what Claudia talked about with just a couple examples, because I think it's helpful for folks to have a couple concrete examples about why an immigration practitioner would need information for their clients through a FOIA request. And I want to say, because I think sometimes we forget this is an ABA panel, we're lawyers, we're speaking to lawyers, but the vast majority of immigrants are not represented in immigration court. So even requesting a FOIA is something that we should not assume happens. When you have an attorney or you are savvy about the system, you will file a FOIA request and ask for information about your record that will be critical to your case. But I just want to make that point because I think that's really, really important. There also is no affirmative notice that is required. So the government does not have to make individuals aware that they can file a FOIA request when they're in removal proceedings. I think it's just important to be aware of that. So here's one example that was provided in, I'll talk a little bit about this class action lawsuit later. Claudia worked on this case, Bradley's aware of this case. It's called Nightingale v. USCIS, and it's challenging the delays in responding to A-file requests that are directed to USCIS and used to also be referred, part of those A-files used to be referred to ICE for further review. We filed a whole bunch of declarations in that case from immigration practitioners. And one example that a practitioner provided was, so for clients who enter the country without inspection, for example, and are returned to Mexico by immigration officials, they don't know, because their experience is that they're apprehended by Border Patrol, whether or not they were subject to expedited removal under a certain provision of the Immigration and Nationality Act, or whether they actually withdrew their application for admission. And so this example is provided because from a legal perspective, the distinction makes an enormous difference. If it's classified as expedited removal, that individual could be susceptible to criminal punishment for illegal reentry, reinstatement of a prior removal order, and a permanent bar to obtaining lawful status. So they are not sure what exactly happened at the border, but they're going to file a FOIA. Their attorney is going to file a FOIA to understand better what happened to that individual. And then, you have other cases where a person might have come as a child, like Claudia said. You don't know what petitions might have been filed on their behalf. This attorney talks about having a client who and representing them in removal proceedings and not having records from prior counsel and not being able to contact prior counsel. And so if they want to understand what happened to this person in their 40 years of immigration history, they're going to have to FOIA for those records. So I just wanted to give a couple examples there so folks really have an idea about what we're talking about. And then I think we're probably in danger of speaking for quite some time on each of these questions because there's a lot of material potentially to share and information to share. But I'll just say, in terms of FOIA and the role it plays in immigration policy, delays are an enormous problem and will talk about some of the systemic issues a little bit later, but FOIA is critical. It is critical for the reasons that Claudia mentioned, because it's the only practical way that people can obtain immigration records about themselves. But it's also become increasingly important to immigration advocates and those who are looking to do fact gathering to file litigation. And so a couple efforts I'll mention where, and I think that advocates, and sometimes we think, how are we really moving the needle through FOIA and trying to get information through FOIA requests? And how are we really pushing on policy? And I'll mention two examples where we requested information and received information about complaints about CBP officers at the border and abuses at the border, and realized through this FOIA that despite widespread complaints about abuse and mistreatment of immigrants in CBP custody, when formal complaints were filed, often no action was taken. And actually, with partners, the council filed a report called No Action Taken. And as a result of that report, there were changes made within the agency in terms of how complaints are received and how they're processed. And to the extent that there is disciplinary action taken against agents, I think that we want to make sure that this kind of oversight continues to happen. And it's a huge amount of work. It requires analysis of data that's not always so carefully collected by the agency. And so oftentimes requires careful analysis from advocates to sort of understand what's there and to be able to recommend better policies. Another example would be understanding huge enforcement programs that just really aren't very well explained to the public. There was a report about the criminal alien program. This is an interior enforcement program where ICE collects biometric data from incarcerated immigrants in cooperation with local law enforcement and removes them through this program. Very little was known about this program until a big FOIA was undertaken to understand it better. Enforcement outcomes under Trump. There was a lot of effort to understand through available data and through FOIA's two enforcement components of DHS, what the comprehensive picture of enforcement under Trump looked like. Family separation is another. Multiple organizations have been looking to understand better what is happening and has happened with family separation. And that's data, better understanding who was prosecuted and why, policies about facilitating communication amongst family members. The council has shared information with our partners about, spin that the administration, how they were spinning the family separation policies when zero tolerance was announced, and all sorts of information about what's happening to asylum seekers at the border. And recently, of course, a lot of investigation into how COVID-19 impacted folks in immigration detention. So I just want to sort of list out, and Claudia knows that just scratches the surface of areas where FOIA has become sort of a key component to investigation and policy work by many organizations who care about the treatment of immigrants and their due process rights.
Thank you very much. A couple of follow-up questions. So I know you said that the vast majority of immigrants are not represented. And it sounds like the A file is very important in removal proceedings. Without the A file, would someone get deported? Is it almost a given that if they don't have that information, they'll get deported, or do they just get into a holding pattern waiting for the FOIA response with the A file?
There's certainly various ways to attempt to avoid deportation because one cannot access their A file in a timely manner. Of course, there are, suggested tactics such as requesting a subpoena from the immigration judge, for example, although the immigration judges are often reluctant to issue subpoenas where they view that FOIA is the proper route for requesting records in government custody. Attorneys get creative, of course, as Emily mentioned, for pro se folks. I think the biggest danger is that you can, for example, in the detained context, if you're facing deportation while in government custody, that could serve to prolong your time in custody as you're trying to gather the evidence that you need to, especially for something dispositive, such as, do I qualify for something in this removal proceeding? And often the government may well have the answers, in a file just across the desk from the detained individual. And so really, I think the delay is the enemy for immigrants in terms of delaying being able to apply for a benefit you may well be eligible for. But of course, you don't want to take the chance you're facing potentially adverse consequences if you apply for something you're not eligible for. Immigration practice is a bit of a minefield sometimes in terms of, filing a petition that, isn't appropriate or, not timely, or there may, as Emily pointed out, be a deportation order that the individual simply didn't know about. So you're taking real risks by proceeding without a copy of your A file. And you can certainly, safeguard against deportation for not being able, due to not being able to access your information in a timely manner, but that timeliness really can have devastating effects for folks. And in particular, I can't stress enough for folks who are in government custody that are often trying to cobble together information, and that can impact the length of detention.
Thank you. And I'm also wondering, when you do receive the records, how useful are they with law enforcement proceedings involved in the exemptions that have to be applied if it's an open investigation or something similar to that? Once you get the records, how useful are they to you and to your clients?
Well, I would say, and I'm sure there's many immigration practitioners on the call today who have a range of experiences with how useful records are once you do obtain them. It really runs the gamut, in my view, in my experience. Simple matters could be resolved with, the information you obtain. But often there are challenges, and I saw a couple of questions quickly where folks are trying to figure out, where can I obtain this form? Folks have, filed FOIAs that come back and there's no record, say, of an encounter with an immigration agency when clearly the individual does remember some sort of encounter with the immigration agency. And crucial, again, to bring up that example is the encounters that may or may not have resulted in a deportation order because of all of the consequences of that. So I think it really runs the gamut in terms of how useful the information will be in an individual case, but it's not unheard of for attorneys to need to file another FOIA, seek another agency, or appeal a FOIA that came back with with information lacking that there's good reason to believe exists out there. And then, in the policy sort of arena, and I'll let Emily chime in as to that, often, that also runs the gamut, I think, of how responsive records will be in terms of some of the FOIAs that we filed, as far as, for example, locations of immigration courts, COVID materials and ICE detention facilities, that sometimes the requests don't come back in as straightforward a manner as one would hope.
And Abby, I'll just follow up really quickly on the second part of the question about, are the disclosures helpful and do you need to appeal them or sue to get records? And I don't want to go too far afield, but I do think it's worthwhile for folks who aren't so familiar with the process to understand a little bit what happens at the administrative phase of the FOIA, particularly with immigration agencies. And we can just speak, Claudia, sort of to the practical, like on the ground experiences that we often have. So I mentioned before, a lot of folks in removal proceedings who may not even be filing FOIAs. If you do file a FOIA, I think there is some misunderstanding about the FOIA process, and even, what to expect from agencies after you file. So to file, after you file your FOIA request, you then have to sort of follow the administrative process, ultimately to exhaust administrative remedies if you want to go to federal court. And I'll stop here because I do spend some time talking to immigration practitioners about going to federal court. But the truth is, most immigration practitioners do not file federal lawsuits on FOIAs. That is a very rare occasion. Typically, folks are trying who have the resources and time to go to federal court to appeal a FOIA request and challenge the agency's failure to respond or to over-redact documents. Those are organizations that are seeking information. There are a handful of immigration practitioners out there who are amazing FOIA litigators, but it's just not a big part of an immigration practice because it's resource intensive. And so I think it's important for folks to understand that. So if following the adverse determination of a FOIA request, you're going to want to administratively appeal that, and you're going to have 90 days after an adverse determination to go back to the agency. But here's the other thing that is a little bit misunderstood. When the agency responds to a FOIA request, they have to respond under the statute and the governing regulations with a determination letter. And so that determination letter has certain things. It talks about whether the agency is going to respond to your request. It has appeal rights language in there. It talks about dispute resolution services that you can access with the FOIA public liaison and the Office of Government Information Services. That determination letter is not the receipt letter. The receipt letter is what you get from the agency, typically relatively soon after you file the FOIA. That is not something that is to be appealed. That is merely the agency saying, hey, we got your FOIA, and you're still waiting for your determination letter. So in many cases, outside of the slightly more expedited track, when folks are in removal proceedings, where the responses move more quickly from the agencies, or when folks are filing very discrete requests, typically you might not receive a determination letter for quite some time, and you'll have to either go to federal court, or you can try to continue to contact the agency and speak with the agency. But there's no need, if you haven't received word from the agency at all, to administratively appeal. You can go straight to federal court. I also think to understand that the agencies are required to respond to a FOIA request within 20 business days following receipt of the FOIA. So, we've had a case recently where we filed a similar FOIA request with two agencies that had documents that would be responsive to our FOIA request. And one, we received a receipt within 2 days. We received your FOIA request. Again, not the determination letter that is going to tell us whether or not they're going to, favorably respond or deny the request. But the other agency did not respond for 2 months. We did not receive a receipt letter. We needed to reach out to the DHS public liaison, who was very helpful ultimately in getting a response from ICE. We just received no receipt notice. So I think that's also hard when you don't do this work, when you don't typically do this work, to understand. And this is, through the online process. This isn't something where, we filed something in the paper process. So I think that it's important for folks to understand. And then the final point I'll make there is that, maybe final 2 points, is that the 20 business days is not for the receipt. I'm seeing the question here. It's for a determination on the FOIA request. That is the amount of time that the agency has to respond. They do often invoke an additional 10 days, which is allowed when the agency sees that there or believes there are unusual circumstances, and that's a need to search for and collect records from field offices separate from the office processing the request, to look at a voluminous amount of records in the agency's view, or the need to consult with another agency. But I would say this additional 10 days is often invoked in response to FOIA requests. And the 20 days after the FOIA request is filed, in which the agency is supposed to respond with a determination letter, is not 20 days, again, where you're not going to receive documents necessarily within the 20 days. That's just a determination letter from the agency. So I just wanted to sort of stick that in the discussion so that folks can sort of understand how this all proceeds. And I don't know, I mean, I want to open it up to Claudia and Bradley to clarify anything there, or to sort of weigh in if that, if there's something more to add there.
Sure, I'll jump in.
Yeah, and I was actually just going to go to Bradley because I'm hearing all the frustrations from outside of the agency, but you described biometrics as getting 45,000 requests a year, unless you have 4,000 people working there to process all of those. It sounds very frustrating on the agency end. So could you tell us more about the challenges facing processing and follow up on that?
Sure. So I'll break that up into two parts, because for immigration records, as in a person is seeking records about an immigration status, the challenge there is the sheer volume of requests. USCIS gets well over 100,000 FOIA requests a year for that information. DHS as a whole receives more FOIA requests than any other agency in the government. We receive almost half of all of them in the government. The overwhelming majority of those are for immigration records. Even if USCIS was a separate department, they would still be number one. And they receive about half of all FOIA requests in the government. Then you get CBP, which is about 65 to 70,000 in an average year. Excuse me. And ICE varies, but it can be between 50,000 and 65,000. And one year when I was there, we did 101,000 FOIA requests in a year. So the numbers are massive. Again, 49% of all FOIA requests in the government, but we only have 10% of the FOIA processors. And that's a massive, massive problem. And, you know, I mentioned funding, and I mentioned staffing in one of my responses, but funding is a problem, because if you're looking at something like, you know, anything in the department here, as important as it is to respond to these FOIA requests, it's not sexy. It's not the thing that's going to get as much attention from the appropriators as some new technology. And we are constantly frustrated by that. On to the process itself. Emily was right in the 20 days, and that we frequently add the 10-day extension. And generally within the process, within the agency, and we all have similar processes. We receive the FOIA request, we send out an acknowledgement letter. In DHS headquarters, and it's supposed to be the process at ICE, it's actually in we have an intake team that receives these requests, logs them in, sends out those letters. And it's in those employees' performance plans that they need to respond to those, log them in within 2 days, respond within another 2 to 3 business days. That can be difficult. We try to hold them accountable, but it really depends on how active the supervisor wants to be in holding staff accountable, and in how much work there actually is. And then you have the tasker, which is what we call when you send out the request for records. At USCIS, it's a little different, because they're receiving most of those requests at the National Records Center, where the documents are stored. So it's a matter of hunting through the cave, find the file, scanning it. Other components may have to, so if it's ICE and someone's asking for records from enforcement removal operations, the FOIA office has to send the request to ERO, ask them to conduct a search of their systems. And it's usually systems now, it's rarely paper anymore, thankfully. So you don't have to send it to the field office and hope they mail you paper back, or email it, or scan it and email it. And then the records have to come back. It is the agency's practice that the determination letter is simply our final response. You're not going to get a letter from anyone in DHS saying, we've received your FOIA request and we're going to release everything in full, because we don't know whether we're going to apply redactions. We don't know whether the records are responsive, if we have them, until we've reviewed them. And in our office, in every office in DHS, it is a person doing a line-by-line review of every single page that they receive. For immigration records, as important as those A files are to the individuals, they're relatively simple to process. When I was a processor, I would have to do 35 to 50, depending on my grade, of those each week. So relatively simple, and sometimes if you're really flying, you can do that in a day. The other requests where they're asking for the number of requests received, the problem is the volume of records that come back. And I mean, I know we talked about this in the FOIA Advisory Council. It is, you'll submit this request for the search and you'll get back sometimes, hundreds of gigabytes or a terabyte of data. And then you have to ingest it and review it. And there the problem is, again, it's always one person per request who's processing it in an office. So a person has to look at all of those pages and determine responsiveness, and then later apply any exemptions if they're applicable. And that process is incredibly time consuming. And honestly, it's inefficient because we just don't have the technology that can weed out a lot of that stuff for us. It is a problem, and it is something that I know all of the component FOIA officers are constantly working on, and it's something that at headquarters we're trying to fix, both through getting more people and through technology, because there's no substitute for a person looking at a record and applying an exemption. But you can use machine learning or other systems to determine responsiveness and to have effective keyword searches to weed those records out. But it is much more complex than we want it to be.
Yeah, it's very, very complicated, as people say, on both sides of this coin. And do you feel like it's a challenge that exists despite any new administration that comes in? Like, do you think things will change under the Biden administration, that you'll get more attention and more resources, or like how does that affect it?
So not necessarily. The resources, possibly, but honestly, a lot of the funding things that we're asking for now, we started in the other administration. And the people who are actually doing the work are career employees. Especially those of us at the leadership level. I joined the government during the Obama administration. I survived the last one. I'm here now. We're still doing the work. It does not change. The exemptions are the same. The law is the same. And we really don't seek any political approval before we file a response to a FOIA request. You're not going to ask the secretary, hey, somebody's asking about family separation. Do you approve of this release? We will not do that. And now the flip side of that is things will wind up in the press, and then we'll get questions like, why did you release this, Bradley White? Your name's on the letter, which is no fun, but that's our job. And our job is to inform the public of what the government's doing. So I really, and this has got me in trouble, I don't care what the politicals think about the record that I'm releasing. If you didn't want the people finding out about it, maybe you shouldn't have put it on a piece of paper. So no, there's not a political consideration. However, there are, appropriations comes into play. If there's a government shutdown, we're not processing FOIA requests. If there's sequestration because, one party in Congress wants to handcuff the president's party, then we're not going to get the resources we need to get new systems, and we're not going to get new staff members, or we're going to have a hold so that whenever people leave, you can't backfill. And that creates a cascade, because the biggest problem in every FOIA office I've been in has been that the workload increases, and you'll have a couple superstars who will process thousands and thousands of pages a week, well above their performance metrics, while and some folks aren't pulling their weight, and then other folks just leave. And as the work piles up on on the people who are really trying to serve the public, they'll eventually leave. A lot of good people left ICE because the workload was simply far too heavy to justify the amount of hours you're putting in, knowing you didn't have any help coming. And when I say a lot of people, I'm speaking of myself here. You did not have the assistance you needed to do the job, but the job had to get done. And you go to a place that only gets 100 FOIA requests a year, and you do your job there, and you're able to see your family, which I kind of like. You know, I like these people in my house. So that politics can affect that, but it should not. And again, I'm speaking from DHS about immigration records specifically. It should not affect the application of exemptions or the search for records. The FOIA officers in the department will fight, and I have been party to these fights, will fight tooth and nail to get records, will fight that a release was appropriate. Those things happen behind the scenes. They're not going to be reflected in the records that are released, and they're certainly not going to find their way to the front page of the New York Times when the records are released. But those things do happen, and I would say that most of us in the department really want to get the records out, especially if it's informing about a program. We want to get those out because the people need to know. And at least at ICE, when I worked there, the FOIA officer would hammer into us from day one. Every single one of these FOIA requests for an A file is a person, and you could hold, you know, a person's future in your hand when it was when we were getting paper requests, or on your screen, with how quickly and how properly you handle this request and get it out the door. And we take that burden seriously.
Yeah, definitely. Wow. And I wonder if Claudia and Emily, do you see any changes in how you interact with the immigration agencies, depending on the administration, or is it pretty much the same, no matter?
So I'll quickly follow up, and then Claudia, you can follow on, because I know you have thoughts about this too. I just really wanted to continue the thread that Bradley raised about funding and resources, because I think this is a huge, huge problem. And we mentioned before, or I mentioned before, that we filed this lawsuit in 2019 because the USCIS FOIA backlog had crept up into the 40,000, A file requests in a backlog, and folks weren't receiving responses to requests for A files, within 6 months or even a year in some cases. And so after filing that lawsuit, USCIS and ICE, there was a lawsuit, there was a congressional hearing, a new memorandum of agreement was arranged or signed by the two agencies to allow USCIS to review ICE portions of the A file. And so movement was made in that direction to expedite things. There was also, and compliance report, these are publicly available compliance reports that have been filed in Nightingale. The second was filed yesterday. They're quarterly compliance reports that the judge has ordered. So in that case, Judge Orrick in the Northern District of California, he agreed that these are chronic problems that the agency has not fixed. And so short-term fixes, surges of resources to hire personnel, to reduce backlogs. Ultimately, the backlog will potentially creep back up. It's happened with other agencies, and we looked at how it had happened over about an 8-year period when we filed the lawsuit and provided that information to the court. And so the court said, look, big increases in requests were foreseeable, particularly under the Trump administration, given historical trends and increasingly aggressive immigration enforcement policies. And so, the agencies failed to convince the court that the bureaucratic challenges just inherent in a large volume of requests was excusing the large delay. And so what I want to focus on is the resource piece, because I don't think anyone here disagrees that that's a huge problem. And USCIS did what the court asked, went to DHS and said, we would like funding from Congress to address the problem with backlogs and with FOIA adjudication. And so what USCIS also did, which I'd like to mention, is asked for and requested through a request for emergency funds around $4 million after the court's order in December of 2020 to pay for contractors, additional scanning capabilities, and all of these requests were granted. And so, suddenly the FOIA program had millions of dollars to address some of these backlog issues, but the much larger amount of money that is needed apparently to correct this, which was requested by USCIS to DHS and USCIS asked DHS to advance this request to Congress. DHS did not do that. And so I think that is a bigger question about whether or not they're willing, whether, DHS, big DHS is willing to go to bat for the FOIA office. And I mean, I don't know how much Bradley can talk about this, but I think that this is a real issue, and it's going to continue to be. And USCIS is a fee-funded agency. We understand that. It's not enough for the FOIA program to meet its obligations under the statute. And so, that's our position. And I think, without some of this additional funding, it wouldn't be able to comply with the court's order. So, I think that we're just looking for ways to help the agency not, have overworked and under-resourced FOIA offices. So I'll leave it there. I don't know if Claudia has anything to add to that, or Bradley.
No, I think, I definitely think that this tension between the big DHS and, essentially the components of the agency that may set policy, including, what types of enforcement actions, for example, are taken against the immigrant community. We just went through an administration that was extremely aggressive in this regard. And there is that tension between, those components taking these actions and the FOIA units within these components that, are responding to requests by the public regarding these enforcement or other governmental operations that impact non-citizens widely. That sort of tension, I think, has always been there in FOIA in terms of resources, in terms of the policymakers versus those, providing the information on policies. And I don't know that it has changed very much throughout administrations. However, the last administration, again, in terms of aggressiveness, created, I think, a scenario where many immigrant rights organizations, individuals were seeking records from the agencies, tied in part to the policies. But I also think, where it may vary sometimes in terms of an approach to FOIA is with regard to how proactive the agencies are being with releasing information, rather than waiting for the requester community to, begin scrutinizing. Their agencies can be at times a little bit more proactive in releasing information that folks would otherwise want to FOIA. And I'm thinking about things like, the immigrant rights community is very interested in conditions of detention. And so there have been various repeated FOIAs looking at inspections of detention facilities, audits of detention facilities. ICE, which is the entity that has those records, periodically posts, proactively posts inspections and materials related to immigration detention, but not always. And so I think that there's variations potentially in degree. But because of this, tension around who makes the decisions for resources within the agencies, that seems, to be pretty consistent.
So I'll jump in really quickly here. So much like we don't let the political appointees make decisions regarding releases and they just stay out of that area, I am not going to touch political decisions related to funding, beyond to say, I always want more money for more people and more stuff to do the work. And I would support any effort that anyone in the advocacy community wanted to make to ask Congress to give us more money for those things for FOIA. But other than that, I won't touch it. With regard to proactive disclosures, when I was at ICE, one of my jobs was to be the one to post the detention facility reviews, inspection reports on both from the internal ERO ones and the ones from our Office of Professional Responsibility to our website. The problem there is the proactive disclosures go through the FOIA office. And so if we're looking at, do I process these 1,000 pages related to a program that's in a FOIA request that's, either coming up on its deadline or overdue, or do I do this thing where there's no pressure? The weight's always going to be on the actual FOIA request. And it's a problem, but that's it's always, no matter what comes up, what happens if it involves disclosure, it's always going to involve the FOIA people here at DHS, and you run back into the same problem. I enjoy doing the proactive disclosures. It was no pressure work, and it's something that's easy to do. You get to put it on the report, like, look, we released 10,000 pages of proactive disclosures this year. All of that looks really good, and it's relatively easy to do, but it doesn't drive down the bottom line. And when our leadership has to testify about our FOIA program to Congress, or when the leadership's asking for additional funding, they don't ask how many pages of proactive disclosures you made. They ask, what's your backlog and what are you doing about it? And has your backlog gone down, and can you show us a trend? So the work is always going to be focused on the backlog to that extent. I would also note that I believe, and it started when I was at CRCL, and I know it continued for some time after I left, that the Office of Civil Rights and Civil Liberties also does compliance inspections of detention facilities, and they post theirs. They do less per year than I know ICE does, and obviously they weren't going on site and conducting inspections during the pandemic, but they also post those to their website. So there could be another resource to see. I'm unsure, how much information they release, all of that, because again, it's FOIA processors applying the FOIA to those records.
Well, I wanted to follow up on a point that you made that there's tension between doing proactive disclosures and processing FOIAs, where you're under this time constraint and pressure, and there's appeals and litigation involved and everything. And I understand that. But if you look at A files, and it's something that we talked about when we were on the FOIA Advisory Committee. If you were to do proactive disclosure of A files by putting them in a closed system where an individual had to use a password to access just their A file rather than having those go through the FOIA office, do you think something like that would help to reduce the pressure, the volume, the backlog, and everything? A different type of proactive disclosure? No?
No, I mean, one, I don't think you can disclose A file records proactively. It has to be a person asking for them. You're talking about millions and millions of records that are in the system. So it's, that even that administrative burden is going to be incredibly expensive and incredibly burdensome. And there's, I know there's no discovery and these A files are in paper. So someone would have to scan them all in, which is an ongoing project right now. They do it when, if there's a FOIA request and there's a need for it. All of that is time and resource intensive. And then, in removal proceedings, yes, in most cases, the A file is sitting on the desk with the attorney, but the immigration attorneys at DHS are not FOIA experts. And so there are things in those records that must be withheld, and they're not the expert on that. So even if there were to be some kind of discovery process created, it would still put the burden on FOIA processors to do that work. It would just be coming from a different place. So I don't know how to fix it. It's something that honestly we've looked at and thought about and talked about when we're not focused on our backlog over and over again over the years. But right now there's no better way to do it. And I recognize the frustration. I share the frustration, but we're stuck with this process because of the need to protect information in the file. And so, yeah, I know if someone's in an immigration proceeding and the attorney has asked for the A file for their client, and there it is sitting in a little Redwell folder, depending on the person, it could be 30 pages to 800 pages thick and raggedy and paper coming out the edge. And like, I just want to see the thing you're holding. It cannot work that way. It has to go through, if not FOIA, we would tell the agency counsel to do it. And I know that ICE's immigration attorneys don't want to be redacting pages before it comes out. If that process were to exist, they would really just turn around and dump it back on FOIA.
Wow. Yeah, I think what came to my mind while you were saying that is something that I heard about Google, where I think 25% of an employee's time can be spent on thinking about solutions to problems and coming up with new ideas. And if only FOIA officers and FOIA practitioners could have that 25% time to try to find solutions to the problems. But when you're faced with, you know, tens of thousands of requests coming in every year, it's very difficult to do that. I share the frustration as well. Emily, you wanted to say something?
Yeah, I just wanted to respond. I'm sure Bradley expects us to respond to that position that, you know, it's not possible to find an alternative solution. I don't think, I think that because it's difficult and maybe perceived as impossible by folks within the agency doesn't mean it's not the right thing to do. And so I have to say that because I think we have to go on record and say that we believe it is worth exploring alternative to FOIA for first-person requesters. And I direct folks to NARA's FOIA Advisory Committee recommendations that speak to this issue. And so that, you know, that was a collaborative effort by agency personnel and the requester community that looked at this precise issue. And that is whether or not we can think about ways for common categories of records that are requested frequently under FOIA by individuals seeking records about themselves within the immigration context for the purpose of establishing alternative processes. And I think that the agencies should do this. And so I understand that there are many technical barriers. A lot of money has been invested in other processes and other systems. But to the extent that we agree that FOIA was, you know, intended as a measure to increase transparency about government operations, by informing the public about what the government's up to improve the government's ability to govern. I think this is a good government approach and possible solution to take tens of thousands, hundreds of thousands of FOIA requests for individual files out of the FOIA queue. That is a real solution to backlogs. The challenges involved there, I know that I'm probably, there are many folks on the government side, including Bradley, shaking their head, saying we've moved past this possibility. Folks would still have to be doing the redactions and you know, sort of undertaking the same process that a FOIA officer undertakes. But I think the due process concerns are tantamount to those logistical hurdles. certainly for folks in removal proceedings. And so I'll just, I'll say that there. And folks are asking about NARA, and I think there are NARA folks on this call who could probably direct you to those recommendations, but I'll put a link in the chat as well.
Yeah, definitely have to find solutions. And again, I know because I work in FOIA for the government, when you're up against it with all the requests coming in, you're working with requesters, and then you're working with people who don't want records released, and all of this going on, with the operations, it leaves very little room in your brain, mind space even, to start thinking about the solutions. And then without the resources and the backing, it's like, even if you thought of the solutions, how are you going to implement them? But something does have to be done. And I do recall us talking about those things, like even if you were to, at the creation of the file, just enter it electronically and not use certain fields in the online portal for people, so that you don't even have to do redaction. But I do get it from both sides. I understand what's going on, but solutions, definitely we have to find some solutions for every federal agency. But I don't want to take any more time from my end. I want to get to the many questions that we have in the Q&A and in the chat before we run out of time. So bear with me. Technologically, I am going to go ahead and start with our Q&A questions. So we have one question from Joanna Sanchez. For some FOIAs, even the one you submit on the online database, they require to address country of origin. How do you address this if you're trying to make the government prove their burden of alienage first and you want to protect your clients? Anyone want to handle that question?
Claudia, do you have a best practice you'd like to share?
I think folks have taken the position that they don't have to provide country of origin, for purposes of locating an individual's file by their name. And I myself have not implemented that, but that is, I think one potential approach.
Okay, thank you. And then the next question is from Jacob Manti. What does the FOIA process look like for EOIR? I don't know what that stands for, but Bradley.
That's the Executive Office for Immigration Review. It's at DOJ, and I honestly don't know. I have no insight into their process.
Okay, all right. Emily?
Yeah, I'll just share a shameless plug for a FOIA practice advisory that we recently updated that has charts about that are for, agencies that we frequently FOIA in the immigration context. And so there's a chart there that has information, and I put it in a couple times in the chat. And so you can look at the process for filing with EOR and the DHS components, and there's other information there as well.
Okay, great.
And one thing I'd point out about the EOIR process right now is that we are hearing that there are pretty long delays in that FOIA process, which is also concerning, since that is for folks, EOIR is essentially the immigration court. So folks appearing in that system are in removal deportation proceedings. And that's, a scenario where the clock is ticking and timing is really crucial. The timely information is pretty crucial.
Okay. Our next question: for a new client with a removal order from before 1996, what would you suggest to learn what occurred? Try them all USCIS, CBP, EOIR? Are there any risks for individuals with removal orders in submitting FOIA requests? So I guess a couple of questions there.
I can just say, on the risk question, I'm sure, you never want to say it never happens, but certainly don't want to say that. But I do think that is a concern that hasn't really been borne out that there is a risk associated with filing a FOIA request. I don't know. I'd be curious to hear what Bradley has to say about that. That is, Bradley, something that people talk about quite a bit. A concern that when they file a FOIA request, that there might be some kind of enforcement action that follows.
Sure. So generally, the only time that should even be an issue is if it goes to ERO and ERO comes back and says the person is a fugitive, and then the fugitive disentitlement doctrine would apply, but then ICE may, or ERO may look at that and have the person's address. Generally speaking, we all have way too much work to do to go around and say, hey, ERO, look for this person. And I mean, it's just, I don't even know how we would go about doing that. It's not something that I have ever seen. Even if when I've had things that came back with where someone was deemed a fugitive, the response from ERO wasn't, now we're going to go get them. The response was, person's a fugitive, we're not providing the records. It's always about the paper. So again, I can't say that it will never happen. Just in 12 years of doing FOIA, I am unaware of it happening at DHS.
All right, thank you. I will move to the next question, and I hope I am pronouncing your name correctly. Nehia Morales. A friend got an email from the U.S. government stating that his B1, B2 visa was canceled. He's out of the U.S. What is the best way to check this is true and get more details? Anyone want to handle that one?
So I believe the visa process is a State Department issue. I don't think contacting USCIS would be the right move there. I think they would likely have to contact the consulate in the other country or the embassy, depends on where they are, for that information, but that's something that's outside of my experience.
Yeah, that's what I'm thinking too, is that it's a Department of State issue. And there's another question from Mandy Yick. Is there a link for the FOIA process as Bradley described it for DHS? So do you have an SOP or anything on the government website describing the FOIA process for people outside of the government?
It has been a long time since I've looked, but I believe, well, one, we have a portal for filing FOIA requests that's headquarters level that identifies where to send each request and who the contacts are. We have an online portal where you can submit information, where you can submit your request information. And again, it's been a while since I've looked, but I believe ICE's page describes which DHS components would have which records. It's something we implemented when I was there because we were getting a lot of requests for USCIS records that we would then have to send over to USCIS when we're talking 100 to 200 a week, and it was a lot of extra work. So we just tried to direct people to the right office up front. But it's been a really long time since I've looked at that. And then also there's FOIA.gov that has a lot of information.
Yeah, I was going to say FOIA.gov as well. Okay, and again, forgive me if I'm mispronouncing your name, Faiza Syed. I'm curious if any of the panelists know the status of the NYLAG v. BIA litigation. NYLAG sued under FOIA to require the BIA to make all of its unpublished decisions public. The district court dismissed the case, but in February, the Second Circuit held that people can sue to enforce the FOIA requirement that federal agencies post certain documents online so that they are accessible to the public. Is anyone familiar with this case?
I'm familiar with that case. That was a very exciting decision where the Second Circuit reversed a district court that said essentially FOIA documents should just be available to the requester. And they said no under the reading room provision. The Second Circuit said no under the reading room provision. They should be available to all. I don't know the status in terms of, I know that the Second Circuit said the district court will decide if a subset of those decisions should be made available versus all unpublished decisions. And just to emphasize the importance of that decision, I mean, I think I want to look and make sure I understand, I have the exact numbers, but I mean, there are only a few Board of Immigration Appeals decisions each year that are made, that are published and made, available by the board. And there was 30,000 unpublished decisions are issued each year by the Board of Immigration Appeals. Only about 30 of those decisions are designated as presidential. So, and you have government attorneys, immigration judges, the board referencing those decisions, even though they're not publicly available. So it's a great decision in our view, and some good language in there about rejecting secret agency law. But in terms of what subset will actually become available and what is happening with that, I'm not sure, but I keep meaning to look. So I will, I can follow up with whoever asked that question.
Okay, and that's Faiza Syed in the Q&A section soon. So, okay. And then we also have a question about, have there been any FOIA requests made around TRIG and CARP policy and discretionary factors? So I don't know what TRIG and CARP stand for. I don't know if any of our panelists do. Anyone?
I'm sorry, can you repeat the question?
Have there been any FOIA requests made around TRIG, T-R-I-G, and CARP, C-A-R-R-P, policy and discretionary factors?
I'm not aware of any, but I foresee a lot of hurdles in terms of having information provided about those programs. Though I think I might not know about some existing FOIAs on those programs and would be curious to hear thoughts and ideas about finding out more. I do know that there have been cases challenging in the implementation of CARP. And so there may be some information that has been shared through those challenges. But in terms of FOIA requests, I'm not sure.
And what do TRIG and CARP stand for? I'm sorry, Barbara.
Oh, TRIG is terrorism related inadmissibility grounds. CARP, I do not remember, but I think it's a USCIS program. Generally speaking, if it's something that's out there and it's known, you can almost guarantee, especially TRIG, it's got terrorism in the name. You can guarantee that there are FOIA requests on it. We publish FOIA logs on the DHS website, and I believe they're searchable, so it is possible to see if there's anything out there. But off the top of my head, I really don't know.
Yeah, that's great advice, to go to the agency's FOIA page and look through the FOIA logs to see who has filed a request for what. That might be your best way to see if there were any other requests out there made for that. And we have another question. I'm sorry, I have a box on my screen that's a problem blocking things, but Deborah Darren, would it be possible to post any links, documents regarding some of the examples Emily gave about reports on ICE actions at the border? So I guess how would someone find the reports on ICE actions at the border and other things that you were talking about earlier, Emily?
So I'm not sure what ICE actions at the border are being referenced, but some of the FOIA requests and litigation related to those requests, in fact, all of our FOIA requests and related litigation are available on our website, and have the actual FOIA there, as well as pleadings in the litigation. And in many cases, documents that we have obtained through the FOIA request and litigation. So I think I mentioned, FOIAs that ask about what's happening on the border. There are a couple FOIAs that we have that ask about metering at the border. Is just one example where what's happening in ICE detention facilities. We have a lawsuit about that, but also filed a FOIA about that. So, that information is available on our website.
And I also just posted the link to hold CBP accountable, which is a site various organizations collaborate and contribute to in terms of abuses at the border, mostly abuses by CBP.
Okay, this is all good to know. And then John Achatz is asking, for online CBP FOIAs, how do you ask for detailed encounter records on lawful entry and not just the I-94 results? So I will repeat that. How do you ask for the detailed encounter records on a lawful entry, not just the I-94 results? Does anyone want to take that one?
So it depends on what's in it. I mean, they may not have any other information in the system. That is an entirely possible thing that could happen. But you might also want to file a request, and I hate that I'm giving my office more work, with the DHS Privacy Office for OBIM records, because that has entry exit records. And you can also, in your request, you can spell out exactly what you're looking for in detail in that request. And you can ask to speak to someone in the office to explain further what you're looking for. Most of our component officers really do like to talk to people to make sure that we can get them what they need. And I know she's on the call. You can always call the DHS headquarters FOIA liaison as well.
And I'm told by colleagues who do much more individual request FOIAs than I do as far as CBP, that in particular with CBP, if the request comes back inconclusive, definitely appeal. Folks sometimes don't go on to appeal, but folks have gotten more documents following an appeal. So when it comes to CBP, you may definitely want to file that administrative appeal.
And I'll share also, because I've been on a couple panels recently, folks just often refile the FOIA. Unfortunately or fortunately, depending on your view on these things. But I do think that sometimes they feel as though they get different responses depending on the FOIA officer.
Interesting, yeah. Okay, we have another question. When a lawyer requests an A file from USCIS, what is the preferred form of documentation for authenticating the subject's identity? Some FOIA agents accept a G28. Others want a second document, but some agents reject formats that other agents had recommended in email exchanges. So I guess, what is the best way to request an A file? What's the preferred documentation for authenticating the subject's identity when requesting an A file? Or is there a preferred?
So if you're dealing with USCIS, I believe the G28 is the best way. With other agencies, so for example, if you're filing a request for OBIM needs fingerprints to conduct the search. So that might be what that question is referring to there. But generally, USCIS needs the G28. ICE likes that form as well. I'm unsure of CBP, but I think they use it as well.
Okay, good to know. We have another question. What would be the legal mechanism to follow in case of an individual who had an asylum interview with USCIS, and after several attempts to obtain a copy of the asylum interview itself through a FOIA request, it has not yet been provided? The person's individual hearing is coming up soon, so they want a copy of the interview, and they've tried to get it through a FOIA request, but haven't been able to obtain it. What's the best way to follow up? So I guess if they haven't received a response to their FOIA and you can only appeal on a final determination, the appeal isn't going to get them anywhere in this case. But Emily and Bradley, you wanted to weigh in, yeah?
I'll let Emily go first.
I'll just say really quickly, the FOIA public liaison has been helpful to us in terms of sort of helping the process along when there's just been no response from the agency within the statutory time period. Also, the Office for Government Information Service, that office has a mediation process, and I can provide a link here. I think we should start accessing these processes more, because I think it helps in terms of oversight and having the agencies understand a little better. And certainly the OJIS office understands sort of where there are issues with responses and timing of responses.
Emily covered everything I was going to say.
Okay, that is wonderful. The next question. Have you ever experienced requesting FOIAs from USCIS, CBP, FBI, EOIR, and ICE within the last year, where your client has told you that they have had encounters with immigration in some way, but the FOIA denies that that information exists? How do you deal with this? And I think Claudia and Emily, you mentioned this earlier, that people were requesting information on encounters and then it came back no records. So how have you dealt with receiving a no records response in those cases?
I think I'd reiterate some of what we've talked about here, which is definitely pursuing records with the various agencies, describing them very specifically, appealing or, following up with the liaison offices. It sometimes is a lot of hurdles to have to jump through, but if the records, do exist, then, all those efforts should hopefully yield those records.
Okay, thank you. I think this is a question that any of you could answer. How true is it that a FOIA response may take less time and be more complete if you submit it using the standardized form or an online form instead of using a letter request? I'll just jump in and say that during this, we're still in a pandemic, and I have been receiving some requests through the mail, which only in the last few months have I been going into the office to actually retrieve mail. So there will be a delay during a pandemic if you're submitting a letter request through the mail. But does anyone want to take that? Is it true that your FOIA response will get to you sooner if you use a standardized form or you use the online form?
So I will say for our office at DHS headquarters, it's much easier, and everyone that's currently using the system that we use, FOIA Express here at DHS, if you file online through the portal, it gets into the system faster. There's, especially if you use this thing we have relatively recently called PAL, which essentially logs in most of your information for us. It's just easier and less time consuming for the staff. However, and that's if you're talking about a record for an individual. However, USCIS has a different system. I am unfamiliar with how their submission process goes. But generally, if you use a form, especially if you're seeking records on an individual, it's easier to make sure that you get everything that the agency needs to conduct the search if you use a form. If you're talking about a FOIA request for something that's programmatic, it's not uncommon to receive a FOIA request that's 10 pages long seeking or more seeking programmatic information. First, it's way easier if you don't submit a 10-page FOIA request, but I get it. You don't want to do those through the online portal. You run the risk of things getting jumbled up. It's better to email that if you can. I will second what Abby said. You don't want to mail it at this point in the pandemic. Even in offices where we have people on site, the mail quickly gets backlogged. And I know at the beginning of the pandemic, we went months without anyone in the office physically to handle those things. So it is much better to submit it electronically if you can.
Thank you. And as practitioners, do you find that your FOIAs go through faster when you submit them on a standardized form or online? Claudia and Emily. I know, Claudia, you were about to say something. But...
And I would say from the requester perspective, it really depends. At least in our experience, it hasn't necessarily been faster one way or the other, although, you know, I definitely want to echo and caveat the mail, paper mail, postal mail delays, that's probably going to contribute. But ultimately it's going to come down, I think, to the nature of your FOIA request, whether it's, complex or voluminous or straightforward. As folks are saying, have indicated previously, sometimes the requests come back without the, needed records. I think those are, I haven't seen that aspect necessarily change, depending on whether you're filing electronically or by postal mail, a paper copy.
Thank you so much. With that, we are out of time. There were questions that I didn't get to. I am so sorry, and I hope that you're able to email the panelists after the program with your questions. But Claudia, Emily, and Bradley, thank you so much for joining us for this webinar today, and all of the audience members for attending, and Kiefer for organizing. Just very grateful and very happy that we were able to address these issues today. And I hope you all stay well and take care. And until the next time.
Thank you so much.
Thanks, everyone.
Thank you so much.
Bye-bye.
Bye-bye.